rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated.
I guess I'll sit here.
Good morning. This is a time set for oral argument in Verduzco versus American Valet, CACV 150138. Each side is allocated 20 minutes for your argument. Appellant, you may reserve a portion of that if you choose to do so. If you do that, you will need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask those in attendance to make sure that your cell phones are off so oral argument is not interrupted. We have read the briefs. We've conferenced the case this morning. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and in due course will be posted to YouTube. So please, as you begin your argument, please state your name and the party that you represent. With that, Mr. Abney, you may proceed.
Good morning. May it please the court, my name is David Abney, here representing the appellants, plaintiffs. A valet company, for the period of time that it has a bailed car in its possession and control, is really the owner of the car. And as the owner of the car, it has a duty to avoid negligently entrusting that car to someone who, that it knows or reasonably should know, will not be operating it safely. There was a lot of discussion at the trial court about duty and about public policy. And there was a focus and a shift and an emphasis on duty between the owner of the car and the valet company. And while that's important, it really just sets up, the relationship is what sets up the ownership rights of the valet company. For that period of time, it's the owner. And as such, it has to be very careful with the car. Its primary duty is really just to protect it and to give it back to the real owner. And part of that, of course, is you don't give it to strangers.
If this guy who was given the Porsche was totally sober and if a background check had been made, he would have looked like a good driver, but he wasn't the owner, and they gave him the Porsche, and the accident happens out on the freeway, or
right.
Would that be a negligent entrustment?
Well, he's a criminal. If he comes up to the valet company and says, "Give me the car," which is what John Morgan did. He said it twice, and he gets the keys to the car and drives off with a $100,000 sports car. He is a criminal. He's attempted theft at the very least. Yeah. What the valet company should have said was, "Okay, fine, sir. Who are you? Can I see your valet ticket?" And he says, "Well, I don't have a valet ticket. Then could I see some written permission from the owner so you can drive?"
Yeah, no, we're not. I'm not sure I stated my question very well. I'm asking a hypothetical, okay, taking out any evidence of inebriation or under the influence of drugs.
You just give the car to
the wrong guy, and an accident happens. Would that be negligent entrustment?
I don't think so.
I realize that's not our case.
Because if you just give it to a stranger who somehow makes a mistake as to which car, and maybe the valet company makes a mistake as to which car and gives it to the stranger, I don't think so unless there's some visible signs of incapacity to drive or suspicion, or he's an actual criminal and he's just being an imposter.
Well,
but that's not in your hypothetical.
Yeah. Okay.
You know, you got an accidental giving of the vehicle. Well, there would be huge liability between the valet company and the true owner.
Sure.
But as far as negligent entrustment, I don't see the negligence. You're not giving it to a criminal, number one, and number two, you're not giving it to somebody who has some sort of problems. And the way it was alleged that the complaint was high on drugs, behaving erratically, under the influence of drugs, extremely intoxicated and impaired, and all of those will conjure into anybody's mind somebody who really shouldn't be driving.
It's a little bit analogous, it sounds like, as you're envisioning the cause of action. It's a little bit analogous to tavern keepers' duty not to serve somebody in that condition.
It's a lot like that, with the difference being that we don't go into that avenue. What we go into is negligently entrusting something that the tavern owner usually doesn't entrust a vehicle to somebody. But here we have somebody who actually has that vehicle in their control. They could say who it goes to, and it's supposed to go to the rightful owner or to somebody designated by the rightful owner through proper means and identification. That didn't happen. The second Morgan went up to the valet attendant and said, "Give me the car," he was committing attempted theft. He was trying to get a hold of that vehicle for his own purposes. So he's a criminal right there from the start. And then when the valet just handed the keys over, he was giving the keys to a criminal. If he had known that, surely he wouldn't have done it. I mean, who would do that? I've been trying to envision how the owner of the car would actually do this sort of thing. And I can see the owner of the car being liable for handing it to somebody who was high on drugs, behaving erratically, intoxicated, impaired. That's all easy. But I had trouble trying to come up with the owners. Somebody comes up to the owner and says, "Give me your car, and I'm a thief. I want to steal your car." Here's the keys. It's just like you're consenting to it. But here it's very clear what happened. They had possession of the car and they gave it to a criminal. And there were sufficient allegations, I submit to the court, that it would pass muster, at least at a motion to dismiss. Now, in summary judgment stage, you might say, well, give me your specific proof and evidence and characteristics that lead you to believe he was high on drugs, impaired, intoxicated, behaving erratically, all that stuff. That's summary judgment. That's grist for the mill.
Somebody might say that.
And it's grist for the mill at a trial, and that's fine. But this is not a trial, and this is not a summary judgment. I went back. I was sitting at the table with my usual nervous funk, and I decided to, in the back of my mind, I was remembering Civil Procedure 101, and I can't even remember. I think it was Barbara Anderson. Well, somebody down at U of A. There's forms at the back of the Federal Rules of Civil Procedure that deal with how you're supposed to allege a negligence complaint. And so I went and on my phone, I found Form 11. It's for a negligence complaint. And here's what it says. On such and such a date, at such and such a place, the defendant negligently drove a motor vehicle against the plaintiff. Second paragraph. As a result, the plaintiff was physically injured, lost wages or income, suffered physical and mental pain, and incurred medical expenses of blank amount. And that's the complaint. That is the entire substance of the complaint. And here, if they had just alleged that the valet company at such and such a date, such and such a place, negligently entrusted a motor vehicle to someone that they knew or should have known was not going to be using it safely, and then an accident occurred, that would be enough too. There's far more than this. This is a very rich complaint. There's a lot of stuff in here about Morgan and about his characteristics, and it should be enough it should have survived on a motion to dismiss.
Are you asking us to reverse both the negligent entrustment ruling as well as the general negligence ruling?
Judge Robert Jackson, I think, once wrote, if you win on anything on an appeal, that's great, and that's all you need. So negligent entrustment, I think, is very clear, very strong. There's lots of facts to support that. The general negligence theory is something that has sort of been sitting out there for a long time, since Ontiveros versus Borak. That you have a general duty of care to the public, and I think it's a wonderful principle. I'm glad it's appeared in the third restatement. This court has edged away from it, has not really embraced it wholeheartedly, has not thrown it out completely.
I think.
But so I don't think the court needs to reach that issue. If I lose on negligent entrustment, by all means reach it and look upon it favorably and embrace it wholeheartedly.
The reason I asked is it seems to me nobody has probably asked for this or made this specific argument, but it seems to me negligent entrustment is a common law negligence claim or cause of action that has developed over nearly 100 years in Arizona, and when you have that, as a matter of tidiness, I'm not sure that we ought to have also floating out in the same case a general negligence claim. Well,
it's for whatever reason, my colleagues down at the trial court were interested in it and advocated it strongly, but they also, fortunately, advocated strongly for negligent entrustment, and that really is the theory that matters most. There's several sections of the restatement that deal with it in various ways. There's a specific negligent entrustment section in the first restatement and in the second, but there's others that deal with this issue of entrusting a vehicle or dangerous instrumentality to somebody that you know or should know would be liable to misuse it.
And you're right. Arizona has, in the vehicular context, a pretty rich history of negligent entrustment cases. But I have a couple of questions. One, let me start with the substantive and then go back to the procedural. I'm unaware of any case in Arizona or any case anywhere that I've been able to locate arising out of or involving negligent entrustment by a valet of the non-owner, dealing with the non-owner. And have I overlooked some cases that are out there, or are there just none that anybody's found?
Well, I don't know if my colleague across the aisle has found any, but I haven't. And what I have found is just a wealth of these cases, and more than have been cited, actually, but I didn't need to cite them because they'd already cited samples of them, where the courts hold the valet company is not liable for returning the vehicle to the rightful owner.
Right.
Personally, I find that very, very troubling. Even if it's the rightful owner who comes before you, you're the valet attendant, and you see that person is falling down drunk, and you hand the keys to them, and off they drive and cause an accident, I can't see how you wouldn't have some responsibility for that. It just boggles my mind that there wouldn't be.
But we, in this case, needn't wrestle with that boggle.
No,
Is
we
that fair?
need not. And that's why those cases are not relevant to this particular case. What brings this case really back into focus is when you drill right down below the surface is who owns the car right at the instant when it's being negligently entrusted. And for all legal and practical purposes, the owner of the car at that point is the valet company. And so then you immediately go to the law of negligent entrustment that applies to owners, possessors, and controllers of dangerous instrumentalities.
I was going to say, as I read it at least, and I'm looking at a case called Acuna, the elements for negligent entrustment in Arizona turn on concept broader than mere ownership. Would you agree? It talks
Possession
about
and control.
Okay.
Yes.
The other question, the procedural question I wanted to ask you about, as I read the really detailed transcript of the interaction between the good trial judge and counsel in this case, on the negligent entrustment case, the briefing claimed or at least hinted that there was a pleading defect as well as a substantive defect. In other words, that negligent entrustment should not have traction in this context. If I read the transcript right, the trial judge addressed the first of those, found that the should have known element of negligent entrustment wasn't properly pled, but then didn't go on because of that to talk about whether, even if it had been, would negligent entrustment as a substantive tort apply here. If that's a fair reading, and I want to hear what you have to say about that, where does that leave us in terms of what analysis would be appropriate for this court to apply?
I think the trial judge was focusing so much on public policy and duty that he didn't focus enough on the complaint itself, because there are ample allegations concerning the negligent entrustment that they knew or should have known, and that there were certain characteristics of this driver that would lead anybody to think you shouldn't entrust the vehicle, plus the fact that he was a criminal. So you're entrusting a vehicle to a criminal who goes out and does bad things with it, which is something that reasonable jurors could foresee. Now, the trial judge veered far away from foreseeability. I think at one point he said foreseeability doesn't matter at all. But it does when you're dealing with a negligent entrustment claim, because it's predicated on know or should have known. So what would have been foreseeable to a reasonable owner that's surrendering the vehicle to somebody who has all these characteristics that were cited in the complaint, and on top of that, who's a criminal? And they would have known he was a criminal if they just checked.
Let me parse those two things out, because I read the pleading, the First Amendment complaint, as relying solely on the should have known, not that they actually knew. Do you read it differently than that?
Yes, a should have known kind of case.
Right.
You should have known from these characteristics.
Right. And as far as the fact that he was a criminal, how would that, the mere fact of the fact that he was stealing the car as opposed to he was impaired to drive, how is that relevant for whether a negligent entrustment claim is pled?
Well, they would have known he was a criminal if they had bothered to ask for identification if the valet ticket, which had not been produced, identification and permission, which was not produced. So at that point, the valet company would have known that he was a criminal. Because they didn't do that, they blinded themselves.
So let me ask you, and this gets back to Judge Gemmel's question. What if they did know this was not his car, but he was not impaired and he was a good driver?
He's still a criminal then.
But how is that relevant to a negligent entrustment claim?
Well, the reasonable fact finders conclude you should have foreseen that giving this vehicle, high-powered sports car, to a criminal is going to result in bad things, damage to the vehicle, damage to other vehicles, or death or injury to others.
How, and I'm reading again from Acuna, though, the element, and I'll refer to as element 4, the defendant knew or should have known that the driver, by virtue of his physical or mental condition, was incompetent to drive safely.
Okay.
How is the fact that he's a criminal make him incompetent to drive safely?
And this may be my mental condition, but what I believe is the way I parsed that out was, in this particular circumstance, the mental condition is I am a criminal. I have no respect for the rights of others, for the property of others, and therefore having that kind of mental condition, which is mentioned in some cases that I cited, that someone who was a thief, who has stolen a car, is not going to be driving it safely because they have no respect for others, and they are going to be in constant dread of being apprehended, and they're not going to be driving safely. So that's how I parse the mental condition there.
Does this court need to grapple with that, given the allegations that he was impaired by drugs and alcohol?
No, you do not. If you accept the pleadings and the complaint, the allegations in the complaint, which I believe the court should, you don't need to go to the next thing about just giving it to a criminal. Although I believe that it's very important that if you're handing over a vehicle to someone that you could instantly recognize as a criminal simply by asking for a few simple things, a valet ticket, and then the permission slip and identification, that sort of thing. I was running a scenario through my head where he comes up to the valet and presents a gun and says, "Give me the keys."
Right.
But that's really not our facts. And in that case, I could see you don't want the valet attendant in an excess of bravery trying to grapple the gun out of his hands or any of that nonsense, and the valet company wouldn't be at fault. Unless it's a high crime area. But anyway, you get to so many weird factual situations, but that's not really this case. Does anybody have a question? I'd like to preserve my time then.
Very well. Thank you. Ms. Vopel.
Good morning, Your Honors. I'm Lori Vopel, counsel for American Valet, Mr. Casey, and 7277 Scottsdale Hotel. Given the court's questions and the answers in the appellant's presentation, I'll go right to the negligent entrustment claim because I think Alkenbrack and the Delsey case clearly foreclosed the other arguments, together with the fact that there's no special relationship here for purposes of restatement section 315. On the negligent entrustment claim, the court honed in on a couple of very, very key points here. First of all, the ground for the judge's ruling. Judge Oberbilling, actually, if you look at page 53, based his ruling on both. He both found, first and foremost, that he is persuaded that he is not persuaded that there are facts either alleged or out there based on the concessions of counsel, both parties, in the oral argument and in the pleadings, that would change the negligent entrustment analysis with respect to the element that Casey knew or should have known of this thief's incompetence to drive. And then secondly, he also found on that same page that I'm going with my initial thinking, which is that the public policy factors here are supportive of the defendant's position. So he did go through, after looking at all of those public policy factors, and said, you know what, I don't think we should extend it to this context.
Is that the only way to read that, or can it be that for general negligence under Gibson, where public policy is clearly in play for determining whether a duty should be recognized, that was for the separate count? I struggle with the transcript.
Right.
It's murkier than
I think, Your Honor, really he was looking at, look, there's no special relationship under Restatement 315, and so therefore I can't impose a general negligence duty here, period. And so I think that the rest of his discussion really was focused on, should we, make a valet company negligent, even under a negligent entrustment claim, where the policy, where on balance, the policies favor not imposing that liability for the first time ever that any court has ever done it. This would be the first case that we know of in the country. And there are good reasons for that.
Cases like this where the courts have rejected liability.
There are other cases where, first of all, Your Honor, where the clear incompetence has existed. Actually, let me split it up into two separate ones. Those are the owner cases. And then here in Arizona, we have two cases that hold that we're not going to make people liable for the negligent conduct of vehicle thieves. And you have a situation there where it's arguably worse in Schaefer and in Delsey, where the keys were left. A child could have come up and taken that tractor trailer. And think of the harm there. And so the court, I think, as a matter of policy, has said we're not going to impose liability in that context. And when you look at that and Arizona's cases on that, combined with these other jurisdictions that have said, you know what, we're not going to impose it on valets or on, and especially if you look at the Knighton case, because that one really looks at more than just the fact that the person is the owner. And, you know, I think it's interesting if you think about, you know, what if, let's say, in this case or in another case, let's say you impose liability here. What if you have a situation where the thief finds, you know, the ticket on the floor, steals the ticket, steals the ID of the actual owner, and you have a situation where just by virtue of the fact that that person is a vehicle thief, you know, do you impose a duty? I'm not talking about negligence and what he did and the specific facts that go to whether he took reasonable steps. But do you, if you impose a duty here, you're also imposing a duty in that situation. And here's...
I'm not sure that's true. And here's why I say that. And I've thought about that a fair bit. Mm-hmm. If the valet here said, no, sir, you do not get the keys until you show me that you are authorized to take this vehicle. On the facts as pled, and clearly we're at a 12B6, so there's very limited, very skeletal record, although a pretty robust complaint. The case is very, very different than this case. Here there was nothing like that. There was no claim of right or ownership other than, you know, hey, give me the keys, here's $3, I'm out.
But more importantly than that, Your Honor, there are no allegations, no factual allegations indicating that he knew or should have known this man was incompetent. And so that, to me,
then it
comes down to whether he's just a vehicle thief, as you have pointed out.
And do you read the First Amendment complaint the same way that it's really a should have known allegation?
Yes, Your Honor, without question.
And there are, you know, the allegations are demonstrable in that, and either they suffice or they don't, and that's a de novo review by this court. We owe no deference to the trial court in that respect. But from your perspective, what more should have been alleged? Recognizing or assuming that plaintiff's counsel had no access to the valet to interview him.
Your Honor, I think that, and this is what Judge Operbillig actually went through with him. You know, is there any allegation here that he was slurring, that he was stumbling, that he was acting in a manner that would give him some kind of clue? And the problem is that they talked about the video here. And the video shows none of that. It shows him walking up.
Is that part of the record that the trial court considered?
Well, Your Honor, the judge asked about that. And what you have here is you have plaintiff's counsel who says, I don't know how to allege facts of incompetence here. He concedes. I don't know how to allege those facts, and he knows.
That's one way to look at it. Another way would be to say, I don't know how to allege anything more than I have.
And that's because they have the video and they know that, Your Honor.
And obviously the video is referred to. We have not seen it. To my knowledge, we don't have it. And to my knowledge, that's entirely appropriate that we don't have
I
it.
understand.
And the trial court didn't either. How is that to be factored in on a 12b6?
Your Honor, first of all, he did not, he basically said, I can't allege more. He said, I do not, and he didn't even offer a proposed amended complaint, Your Honor. And it really did come down to, this is all we've got. He was behaving erratically. And I want to point out, Your Honor, the Acuna case, because I think that's an important one to look at. It was written by now Justice Palander. And if you look through, now that one did go all the way to trial. The court reversed, and it reversed notwithstanding all of the evidence of the husband's post-accident behavior. He fled the scene, he was slurring, he was stumbling, and the reason for that is that there was no evidence, and here I'm making the comparison, there's no factual allegation, that the wife, who was even with him, knew or should have known. Because there's no allegation that she was with him when he was drinking to excess. There's no evidence that she knew or should have known that he had a bad driving record. There's no evidence, any evidence, and here I would say no allegation, that would put her on notice that he was behaving erratically, or excuse me, that he was incompetent to drive. And I think really what is happening here is that all of the allegations are going to his state. And in fact, in the opening brief, that's all they addressed, not the fact that there's no allegations of knowledge, Your Honor. And if I can just take it one step further, you have a situation here where, you know, if you say, well, you know, they're saying, we can't really, allege any facts, but let it go past the notice stage, you're recognizing and saying, yeah, there can be a duty in this context. Are you going to make, and this is what the Knighton court looked at, that if police are not even liable for detaining and releasing a drunk driver and not liable for what happens after that point, how can you make a valet liable for that? Are they going to need to give drug tests and alcohol tests? What kind of standard are you setting up for this?
And I understand that, although again, those cases conceitedly are in the true owner context as opposed to the stranger. And from the pleading perspective, again, the short and plain statement, not necessary to allege evidentiary details, knowledge and other conditions of the mind of, and I'm reading from rules of procedure, of the mind of a person may be averred generally. The test is whether enough is stated to entitle the pleader to relief on some theory of law susceptible to proof under the allegations made. Those are extraordinarily lenient sort of construction principles for what notice pleadings require.
I agree, Your Honor, but I do think you have to look at whether there's a duty in this context at all to begin with. And even determining, are we going to, because it doesn't fit the restatement, section 315, which is where we normally impose.
Although Acuna used slightly different elements than that, and Acuna, and I appreciate what you're saying about Acuna, but there's a certain risk and lack of symmetry in relying on a post-trial motion versus a 12b6 motion.
And I do understand that, but Your Honor, what if they were able, my point is, what if they're able to show all of that, and apparently that is all that they can show and allege, then, you have a situation here where I think the bar, if you're going to impose liability on someone to control and impose a duty to control the conduct of another person, that bar should be pretty high. Negligent entrustment is one of the few claims that even allows you to get into foreseeability anymore. And in Arizona, I would argue that whenever you are deviating from restatement section 315, and requiring a special relationship, that with all due respect, when you're applying it in a new area, that the bar should be pretty high with respect to what's alleged, and that you should look at policy at that point. And that's what this judge did. He said both that there's a problem here with the allegations. As far as I can see, you're only alleging that he was erratic, and then you have concessions, basically, and then a failure to offer a proposed amendment. But then he also said, what if you could, what do I let this claim go forward on public policy grounds? And he's saying here that there is so much good, that valet companies do. And as the Knighton case showed, first of all, they don't own the vehicle, even temporarily. They have very transitory control. In fact, bailment says they hold the property. They don't own the property.
But they don't have to under a negligent entrustment theory. It's owner control.
That's true.
The cases that Arizona has recognized and discussed this are in the owner context, not where, viewing the complaint in the most favorable respect, no action is taken by a valet company to determine ownership, and a stranger gets the property.
I think, Your Honor, though, that there has to be some kind of nexus between what this valet did or failed to do and the risk. And there is no nexus there. And Schaefer and Delsey said, you can't go make the leap that just because a car thief gets the keys to a car, that person necessarily that it's foreseeable that person is going to get into an accident and drive recklessly. Two cases.
There is a difference between leaving one's keys out
I think it's worse, Your Honor.
and affirmatively handing a vehicle over to somebody who's not the owner.
On the allegations of this complaint, you have a valet attendant who admittedly should have checked, but who gave the keys to someone who was, by all accounts, according to the allegations in the complaint and the admissions of counsel below, walked up and appeared to be incompetent, or competent, excuse me, a competent adult. If you're leaving keys in a vehicle, and we're saying two cases now, you can't hold that person liable for the conduct of that thief. You have a situation where anybody, and I'm talking a 6-year-old, could go up and start that car and cause major damage to that child and to others. Here, could have as a matter of public policy that anybody who gives keys to a child, it negligently entrusts it. I think that's makes sense based on, the other cases and the definition, the pure definition of incompetence. But here you have a situation where really their argument is that the incompetence piece, it doesn't matter. It doesn't matter whether or not, because they even acknowledge that their negligent entrustment claim comes down to giving it to a thief.
And I understand the position of the parties with respect to whether thieves drive faster than owners. And if that's all this case presented, I think it would be a very different case than what I think it does present. But with respect to the true thief cases, and if you cut out in a hypothetical the valet for a second, isn't there a difference between simply leaving the keys in the car and having a stranger come and take your car and not be liable for negligent entrustment versus having the same thief come and without force have you give the keys to that person who is drunk and high?
Well, if in that negligent entrustment is one of the few claims that turns on a foreseeability analysis, then no. I think that you can say that the same would hold there with respect to a thief. And in fact, that's what Schaefer basically looked at. They applied the analysis of pre-Gibson.
So help me understand that. So if the true owner is, and it's a bad hypo, right? Because how do you give keys to a thief when you're not compelled or forced to? But if the true owner does that, work with me here, knowing that the thief is drunk and high, isn't that negligent entrustment?
Yes, because you have more that they know that that person is drunk and high. And so I think that is separate and apart from, here they really are saying, here's what our claim is based on. And I think it's really because, honestly, under Rule 11, I think they know they can't allege more facts based on the evidence that they do have. And that's why the judge asked those questions. You can't just consider that in a vacuum. It's what can I reasonably allege under Rule 11, and he's saying, I can't. And so that's why the shift then goes to, he's a thief. And it goes right directly to where Schaefer and Delsey said, you can't go.
Can I ask, and perhaps I'm misrecalling, but I think there's an answer to this. You're right that there was no second amended pleading tendered, but wasn't there a request to amend that was denied?
He did request it, but, Your Honor, he then didn't propose anything.
Right, but I thought the minute entry from the hearing indicated that the request was denied. Now, that could be, obviously there's an answer to that, and I may be misrecalling.
No, what he did was he found that it would be futile,
right.
and not just based on, that was based a lot on all of the concessions, by counsel as to what he can and can't allege in this case. And you do need to look at it in this case. And he's saying, and the judge is like, I don't think there's any facts out there that he can allege under Rule 11. And he's basically conceded that fact. And so then you do come down to a situation as to whether you're going to allow incompetence, essentially, to a vehicle thief, that should automatically equate to and give support incompetence element, and the courts say no.
Solely on the fact of being a thief.
That's correct, Your Honor. Unless the court has additional questions.
Thank you, Counsel.
Thank you.
Mr. Ebney.
Sorry, my electronic device has the better of me, I'm afraid. Delsey was my case, and of course it broke my heart because I lost it. Sometimes I still wake up at night, if there's something else I could have said in Delsey that would have changed the court's minds. And it goes back to Schaefer Motors, which is the real culprit or the real source, because the Supreme Court said leaving the keys and leaving the car unattended with the keys in it, there's not going to be a cause of action. So Delsey was, I suppose, I guess I was doomed. But I had the same law firm on the other side, the defense side, and that time they weren't arguing that this was a terrible thing, leaving the keys in the car. They said, well, there's no cause of action here at all, and you're out on your ear. But those cases are significantly different. There is no one screening the person who was coming to take the vehicle away. There's no opportunity to see what is up with that person. The trial judge, and I have immense respect for Judge Oberbelling, but when he gets an idea in his head, you've got a difficult argument. And coming into the argument, you can, by reading the transcript, he was focusing on the public policy, the good that valet companies do. Well, okay, you can assume they do some good. It's sort of convenient at times. But the real public policy, I believe, here is protecting the public from people who shouldn't be driving. The true duty in the case is the duty to protect, and that's in the law of negligent entrustment. That's why it developed. That's why Arizona has been strongly in favor of it for, I guess, almost as long as we've been a state. And it goes back to the 19th century. I think you can even go in the 17th century was the first negligent entrustment case I found. It was a servant entrusted with a loaded firearm, but 1816 or so. So it's been around a long time, and it makes sense. Here, the negligent entrustment allegations were not just behaving erratically, which is what Judge Oberbelling focused on and came back to time and time again. It was high on drugs. That's paragraphs 22 and 23 in the complaint. Under the influence of drugs, paragraphs 64 and 109, and extremely intoxicated and impaired in paragraph 109. The only really conclusory allegation was incompetent to drive safely. I mean, that's the ultimate issue, but that was at the tail end of paragraph 109. And then in paragraph 110, they have one of the summary allegations that the valet company and the valet attendant knew or should have known. And basically, should have known is what they say. Should have known that Morkin, by virtue of his physical or mental condition, was incompetent to drive safely. And under those allegations, he was. Now, at trial, when we get the summary judgment, and at trial, we're going to have to come forward with a little bit more to convince the jury, I'm sure. And I hope and trust that we can do that. Morkin was a thoroughly bad character, and this whole series of events is just so astonishing that when you tell it to people, you do the elevator test with somebody, you get on the elevator, and you have time between floor 1 and 10 to tell them about your case. You could tell this to anybody, and their first reaction would be, they did what? They gave the car keys to this guy who simply comes up and says twice, give me the keys, and they give him the keys, and they have all these other things. He's high on drugs, he's acting erratically, he's impaired, he's intoxicated, and you give him the keys. And he's a thief. And naturally enough, a reasonable jurors could say, well, it's foreseeable that bad things are going to happen. That car is going to get wrecked, or it's going to wreck other cars, or some people are going to get hurt, or somebody's going to die. This is just not a good situation. Let me see if there's a couple other things here. The defense tends to frame this as a duty to control the conduct of another person. No, it's a duty not to negligently entrust the car. I suppose in an esoteric sense you're controlling somebody's conduct by not giving them a dangerous instrumentality, but the duty is much more direct and much more clear. It's the duty to avoid negligent entrustment. And I think that's pretty much it. If there's no other comments from the court or questions.
Thank you, counsel.
Thank you very much for your time and attention.
Counsel, thank you for your argument this morning. Thank you for your briefs. You've given us much to think about. I appreciate it. We will take the matter under advisement. We'll issue a ruling in due course. We'll also take a break so we can set up for our next oral argument. Thank you all.